Again, today we're just covering live Q&A to get caught up on questions. So the first one we're going to take has to do with qualifying your tenants. And the question written in is, if I have applicants coming in from France, international applicants, they do not have US credit, but their company is willing to co-sign, how do I qualify these applicants and how do I write the lease to make sure I am protected?
So this is specific, this question I think is really specific to applicants that are not US citizens, which is a little bit tricky. It's different than how we typically qualify people, but there is a method and a way to protect yourself. And Darcy's really good at explaining that, so I'll let her just take it.
So the first thing we like to say when we're training our agents is no credit is better than bad credit. So at least you're stepping into an unknown versus a known bad. That said, it's a risk. Our rule of thumb in our company is you always attach a living, breathing social security number that is qualified to the lease. So let me ask you, do you think a company is a living, breathing social security number who can be held accountable and is qualified for this lease?
Would you take a company on a date? Would you let a company walk your dog? I don't know.
So let me tell you a story. We had a client recently. He had a property outside of our service area. I believe he worked with a realtor, not someone specialized in leases. And he signed a lease. This was a celebrity. He signed a lease in one of the celebrities' companies or holding names. Lo and behold, $200,000 worth of damage later when that celebrity moves out. Do you think that landlord was able to hold that company accountable for that lease? The quick answer is no, because a person can have multiple companies and they can be set up as corporations. And if you move all the assets and all the money out of that corporation, how is a landlord going to have anything to go after if there are damages to go after in court?
This guy was very savvy, has a really great management team, and they basically set him up so he would be protected in the event there was a large loss or a lawsuit against him. So the bottom line is that companies are just like what they are. They're companies, they're boxes. And the moment that money leaves that box, we don't know if that money's ever going to come back into it. And it's hard to hold a whole company accountable. Also, there's going to be multiple layers that you're going to have to go through in order for you to get to the decision maker who's ultimately going to decide whether or not to write you the check or pay your bills. And if that guy, you can't find that guy or that guy quits, it's a huge mess and it's going to be challenging and costly for you. And you may as well just give up and take your L and walk away and get something else.
Yeah, so basically this comes down to risk management. So if you're a landlord, if it's in our company, we are not going to recommend it. That said, you as an individual landlord have a right to make a business decision. If you decide to take this risk and accept the international applicants with no US credit, so you've got no idea, you can, trust them, cross your fingers and hope that they're telling you the truth. You have no idea how qualified they actually are. And if you want an additional layer, go ahead and sign the company. But again, from our experience, we have seen multiple times over the years, international applicants who come with US credit, they could break the lease and the landlord has no recourse because these people don't have a US social security card. You can't go after them in collections. You can't go after them in court. They can leave the country. Good luck. So you're left high and dry. We've seen this multiple times.
We actually have had this happen. We've had this happen where we've had tenants who actually qualified and they had a backer and then they left the country and left. Fortunately, our client, we protected our clients. They had enough security deposit to the tenants actually took good care of the property, and there was enough money there to cover the rent until we found a replacement tenant.
But that's a lucky scenario.
That was a very lucky. We were very fortunate in that scenario. But we did set up some safeguards. So why don't we just talk about some of the safeguards?
Yeah, so the safeguards, our cure for this is, first of all, the best thing to do is get a qualified social security number attached to that. So sometimes in the case of small companies, we've actually had a member of the company who will sign and essentially they're becoming the personal guarantor. That's my preference for having our clients protected. Second to that would be the cure for not being able to prove financial history is to pay the rent up front. Pay 6 months to 12 months up front. And our latest hack is we love to take those 6 months up front, but put them on the back end of the lease. So that's what provides the landlord with the absolute most protection.
And so just to kind of talk through how we construct that. So they would pay the security deposit for all of our properties. We always take the max security deposit, which is 2 times the monthly rent, plus the first month's rent. That's the move-in. And then they would pay an additional 6 months or whatever advance rent. That money would be paid in advance, but it would be applied to the last portion of that rent, of that lease. So if they're renting for 1 year, they'd pay the first month's rent plus the 2 months security deposit, and then they would apply 6 months to the last end, and so last portion of that rent, that lease, and they would pay months 2, 3, 4, and 5 going forward, and then they would have to pay your rent.
Yeah.
6, 7, 8, 9, 10,
And we've
12.
seen people do it in smaller increments, in 4-month increments. I think one thing you want to stay away from is 2-month increments, because there is kind of a gray area where it could be construed that you are taking a higher security deposit than the 2 months allowed by law or 3 months.
Well,
furnished. So-
what you want to make sure you do is outline how those funds are supposed to be utilized within the confines of the lease contract. So you just want to, if you have a ledger that's part of your lease, and if you're using the leases that we use, you'd have a ledger, and it will outline how those funds are supposed to be used. There's a line for security deposit, there's a line for first month's rent or prorated first month's rent, and there's a line for other. And you would just outline what that other is for.
Okay, so thank you. That was a good question. All right, next question this is from Susan. Susan says, what are the 3 biggest mistakes a DIY landlord can make?
Well, Susan,
That's a juicy one.
That's a good one.
I like that question.
There's a lot to that's a good one. I would say the first mistake that I see DIY landlords make over and over again, I've talked about this and I've almost beat it down quite a bit, but it's failing to understand that when you buy your investment property, you're also buying a business. So failing to run your investment property like a business, and subsequent to that, there are the things that we see people make mistakes all the time. Number 1, failing to qualify your tenants before they move into the property. So not getting an application, not verifying references, not running the credit on your own versus taking their credit report. That's number 1. Not having an up-to-date lease that outlines all the new legal terms. And as we know, California is just full of new legislation in 2020. In addition to everything else that's going on, the California rent control laws and rent protections and all that stuff, they're literally changing their leases and in terms almost every single month right now. So
yeah, I would probably add, the most important thing is failing to keep up with the current legislation, or entering it with the mindset that this doesn't matter, it's gonna be fine, it's my house, I lived in it, I know this house, I'm just gonna rent it and it's gonna be easy. And that kind of goes back to the mindset.
Oh, I have a guy that can maintain it. Right?
Yeah, but it's like not setting yourself up for success by thinking about this as a business, which it is. And here in California, it's often at least $1 million business, and there's a lot of risk. And with any business, if you were starting $1 million business, you wouldn't start it without process, procedure, some organization. So that's probably the biggest.
I mean, if you paid $1 million for anything, you're going to want to make sure that it doesn't lose money, right? So, and you have to think about this long term. So if you have a buy $1 million business or a property worth $1 million, you're hoping that it's going to improve in equity, it's going to appreciate long term, and the property is also going to appreciate in terms of how it looks and everything like that. But if a tenant damages your property, or if you don't take care of your property, you're devaluating your asset, and you're devaluating your property and your business. And with that, you're not going to be able to sell it for more. It's not going to be worth as much. You're not going to be able to make as much from your business.
All right. I'm glad you bring up $1 million purchases, being that I have this birthday coming up. I think your mindset is in the right place.
Well, I think you might be setting the bar a little low for yourself, because you said $1 million. I was going to go up a little bit higher, but hey, I can, less is more.
All right. Next question. So this comes from Wes. Okay, this is a meaty one. Wes says, I have a 2-bedroom condo in the Canal. My tenant of many years sublet the 2nd bedroom to a couple. The primary tenant died in May. The sublet couple, who are not on the lease, allowed another couple to move in. I now have no written lease with any of the occupants. They have paid rent on time, but I would like all of them to move out so I can remodel the unit and bring the rent to market value. Help. In caps.
Okay,
Help.
so the first thing,
all right, let's break this down.
I remember reading this, and the first thing I thought is you need to call an attorney. Get a landlord-tenant attorney involved, explain your case, because they're going to give you the best advice and help you serve the notices or anything you need to do legally and properly so that you don't set yourself back. That's number one.
So let's back this up. For those of you who don't know, we are under COVID legislation. We are under rent control legislation. A lot of new rules have come into play in California since January of this year, and then since obviously the pandemic.
Right.
So we would have given you a different answer 6 months ago. We would have given you a different answer 12 months ago. And this is what we're talking about needing to stay on top of the legislation. So here we're going to have to tell you need to consult an attorney, because the AB 3088 that went into effect immediately as of August 31st affects this. But basically what you need to do is ask yourself a couple of questions. Since the rent control rules now apply to everyone, you can't kick people out just to remodel. You cannot do cosmetic remodels at this time.
Yeah, so that's not a cause. The only way you can get somebody out to do a major remodel or renovation is if there is a health and habitability issue inside the unit. This is going to be in effect at least until the end of February.
For units that are not covered by AB 1482, which went into effect in January.
But are covered by AB 3088.
Which went into effect.
Which is everybody.
Everyone's covered. So basically, for those who don't know, AB 3088 means everyone's covered by the eviction protection rules, whether you were exempt or non-exempt from the rent control that went into effect on January 1st. Everyone right now in California is covered by AB 3088.
Until the end of January,
until it gets extended.
I don't know. Do you think California's going to change it?
Are they going to extend it? Are they going to change the rules? I don't know.
They've only
extended
it every single month. So just beware of that. But what you would want to talk to your attorney about is everything said. How can I get them out? I want to do something different. They're probably going to advise you to get them on some new type of lease. So you want to know who's going to be in your property. I mean, that's paramount. Regardless if they're not the people you put in there, you're going to want to know who they are. And you're going to want them on the lease so they can be jointly and severally liable for the rent. And that's a huge thing. You want to make sure you have someone to go after in the event somebody stops paying rent. And if they stop paying rent and move out, that might be great for you because your goal is to get them out and renovate. But in lieu of that, you want to make sure you know who's in your property.
Right. But again, some of these rules, this is why you need to talk to an attorney, whether that could be construed as materially changing the lease, the fact that there is no lease. And then you probably get into whether you've given these guys implied warranty of housing because you've known about them and known about this happening and haven't done anything. Plus we're under COVID. Plus the courts are backed up. Like this could play out a number of different ways. But let me pose something to you. Is it really necessary to get these people out? You said they're paying rent on time. Well, guess what? That's than huge. A lot of tenants in California are doing right now. If you have tenants who are paying rent and are not causing you problems and are not causing any habitability issues, not issues with the neighbors, I would probably not suggest kicking them out right now in the middle of COVID. I'd probably save your pennies, plan for your remodel in the future, and just sit tight right now.
That's great advice. I think that's really great advice. So you just hold out because you're not going to be able to do anything really until they do something. So be nice to them. As nice as you can. I mean, I'm serious. You want to be nice, be friendly with them, and be partners with them. And then the other thing I'd say is
talk to an attorney.
But definitely talk to an attorney. Landlord tenant attorneys right now they have a lot of calls like this coming in. So if they don't get back to you right away, just be persistent. But also, it's going to be worth the cost to pay someone like them to do it. You want to make sure this is done right. Even if it's going to cost you $1,000 or $2,000. I don't know what they're going to charge, but if it's going to cost you some money, it's worth it long term because it will save you lots of money and lots of headaches down the road.
Right. So I'll tell you how we would have approached this differently. If we had been managing this property, you would have had your primary occupant. You would have heard at some point become suspicious that maybe they'd moved in some additional unauthorized occupants. We do annual inspections. That's one way we uncover that. Also, sometimes our vendors, because they're trained to know what to look for, they might report what looks to be a lease violation to us. So we maybe would have found out about it. As soon as we found out about it, we would have taken action. If it was in a pre-COVID world, it would have been a notice to cure or quit. It would have been something like that. In a post-COVID world, it would have depended where we were on the scale.
I think that's a great time for me to tell a nightmare story.
Okay, let's hear it. We love these.
So years ago, we had a property in Marin that we rented it to. This person actually happened to be someone who wasn't a U.S. citizen, but they also paid advance rent plus a security deposit. We got notified by the owners because a neighbor had contacted them saying, hey, there's a dog there. There seems to be a lot of cars at the property. You might want to have your property management company go check it out. So we did. Walked around the property. In addition to seeing the dog, which wasn't allowed, we saw cigarette butts.
Not allowed.
Also not allowed. We saw a lot of things that were going on at this property that weren't allowed. And when I talked to the owner, talked to the tenant, she let me know that, oh yeah, she met somebody, a friend of hers, and they're staying there with their children, and they're going to be helping her with the rent. And that's when I said, this isn't going to work out. We're going to have to ask them to leave or have them qualify.
Didn't they have like a kiln in the garage or something?
Yeah, she also had a kiln.
There
was a huge mess.
Yeah.
Long story short, this tenant and her friend got into an argument, and the friend contacted the police and actually had the current tenant temporarily displaced out of the property. She left and was not allowed to come back because a restraining order was filed against her. This friend actually is a con artist, and she had done this multiple times before, as we found out. the owners were left okay. The property was, after we had enough money in security deposit to fix what little damage was there, but that was a worst case scenario. So anybody who's listening to this, not Susan, obviously Susan's in a better position, but anybody who's listening to this, you got to be very wary of things like that. Unauthorized occupants can cost you a lot of money, headache, and also stress. My clients happened to be in Europe at this time, and they were stressed out, but we took care of it, fortunately, for them.
Yeah. And again, since the original occupant, the one we'd approved for the property, didn't have U.S. credit, we had taken those 6 months prepaid rent. We were able to draw from all that money for the damages to cover unpaid rent, to cover attorney's fees, because they were significant to get this, what essentially became a squatter, out. And our original tenant got out of Dodge. She went back to Europe, and she wanted nothing to do with any of this. But we were able to handle it for our clients.
All the repairs, everything.
For our clients who also lived in Europe, they were left whole, and they were very grateful that they had decided to hire a property management company instead of just hiring us to do the leasing. If she'd hired us to do the leasing, they would have been teed up, but they would have been having to deal with all this. So just one more point before we close out on your question, Wes. One other option, if you really do want to get these people out, all these 4 or 5 unauthorized occupants, whatever you have, cash for keys is always an option. And how much you have to pay would be subject to negotiation, but that is absolutely a topic and a solution that is coming up in today's post-COVID world.
But have the attorney write it up,
Yes.
And write the release, all that stuff. You want to make sure it's all legally documented.
Yeah, and they don't get the money till they move out. You give them maybe a little something on the front end, and you give them the back when they have literally given you the keys, hence the title, cash for keys. So we do see that coming up as a solution today, for sure, since evictions are very tough right now.